Without free speech, no search for truth is possible. Without free speech, no discovery of truth is useful. Charles Bradlaugh.
Freedom of speech is the most sacred right in American democracy. Prior to the Revolutionary War, the Magna Carta and the English Bill of Rights granted individuals some basic rights, but they did not permit freedom of speech, a restriction that many colonial Americans resented. After the Revolutionary War, the framers of the Constitution placed special emphasis on guaranteeing liberty and individual rights for all citizens. The framers of the Constitution were very clear when addressing freedom of speech. Their intention was to allow citizens to express their ideas and opinions without fear of retaliation, especially when discussing the government.
Congress shall make no law abridging the freedom of speech. First Amendment, ratified 1791.
The concept of freedom of speech has been constantly challenged, reevaluated, and redefined since the Constitution was first created. The country and the culture have evolved beyond what the framers could have envisioned, and the Supreme Court has repeatedly ruled on what is free speech and when it should be limited. Free speech is classified in two ways: pure speech and speech plus. Pure speech, any direct form of written or oral communication targeted toward a specific individual or group, includes face-to-face communication, broadcast speech, or written publications. Speech plus may involve direct communication, but also includes expressive conduct. Expressive conduct must involve an action such as distributing pamphlets, picketing, or participating in a public protest. Since Speech Plus incorporates actions in addition to spoken or written communication, it is much more difficult to label as acceptable or unacceptable. Another example of Speech Plus is symbolic behavior, a broad designation that includes activities such as civil disobedience. Burning a U.S. flag, a selective service draft card, or an effigy are some of the best-known examples of symbolic behavior. Interpreting symbolic behavior is challenging, as it is often difficult to separate speech elements from behavioral elements. The foundation of the United States includes key acts of symbolic speech and expressive conduct. The Boston Tea Party, for example. In light of our country's history, courts today almost always support freedom of speech, unless criminal or potentially dangerous elements are involved. Americans have been skeptical of limiting First Amendment rights, challenging limitations on free speech at every opportunity. The Supreme Court has been equally reluctant, limiting speech only when it proves to be slanderous, egregious, a threat to public safety, or a national security risk. Freedom of speech is most often called into question when words are used to encourage or promote unlawful actions. The Supreme Court developed the clear and present danger test in Schenck v. United States, 1919, ruling that the government may prohibit speech that creates an immediate threat of criminal action.
The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. It does not even protect a man from an injunction against uttering words that may have all the effect of force. The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. It is a question of proximity and degree. Oliver Wendell Holmes, 1919.
In 1925, the court established the dangerous tendency test that attempts to measure the likelihood of violence or danger resulting from questionable speech. In Gitlow v. New York, 1925, the Supreme Court upheld Gitlow's conviction for distributing socialist propaganda that supported the violent overthrow of the government. Though most forms of symbolic speech are protected, there are limitations. The government can regulate speeches in a public forum or special facility, for instance. Other limits on free speech involve obscenity, defamation, and speech leading to unlawful actions. The protection of commercial speech or advertising can be limited as well. The government can prohibit false advertising, prevent the marketing of illegal products or services, and in some cases even regulate legal products. In 1986, the Supreme Court ruled that the government could restrict advertisements for outlawed products, a ruling that has since been used to restrict the marketing of alcohol and tobacco products. The court has also defended controversial commercial speech. In 1999, the FCC banned New Orleans radio stations from airing advertisements for legal casinos in Mississippi, arguing that they promoted immoral behavior. In Greater New Orleans Broadcasting Association v. United States, the court ruled that since the ban on casino advertising would have no effect on limiting the hazards of gambling, it violated the First Amendment. One of the most commonly regulated uses of speech is fighting words, words that inflict injury or tend to incite an immediate breach of the peace. In Chaplinsky v. State of New Hampshire in 1942, the Supreme Court upheld Chaplinsky's conviction for calling a city marshal disparaging names. The court argued that fighting words do not convey ideas and are therefore not protected by the First Amendment. Later, the Supreme Court upheld the use of fighting words. Arrested in 1970 for wearing a jacket with an offensive political message written on it, Paul Cohen was convicted under a California statute prohibiting the malicious and willful disturbance of the peace. Yet the Supreme Court set a precedent by overturning the conviction. Since the expletive was not directed at anyone or intended to provoke group action, the court ruled it protected speech. The Cohen case immediately changed the perception of free speech and has since broadened the scope of acceptable speech. An extension of freedom of speech is peaceful assembly. The First Amendment allows citizens to speak, protest, or picket on public property as long as they do not disturb the peace or violate the law. Dirk de Young, a proponent of criminal syndicalism, the advocating of violence or sabotage, tested this protection in 1934. After his arrest, de Young filed an appeal, contending that there was insufficient evidence to warrant his conviction and that his right to free speech had been violated. The Supreme Court agreed, overturning his conviction in 1937 and setting a precedent for future discussions about peaceful assembly. Despite the significance of the de Young ruling, the court has limited free assembly when necessary. In 1941, a group of Jehovah's Witnesses were arrested for parading without a permit while distributing leaflets. The group appealed their conviction, citing their right to peaceful assembly on public property. However, in Cox v. New Hampshire, 1942, the court upheld the conviction, stating that municipalities have the right to ensure the safety and convenience of public streets. Today, freedom of speech remains the most sacred right in our nation's history. Though the First Amendment has been, and always will be, challenged in new ways, both the American public and the Supreme Court continually fight against any limitations to their freedoms.